boy, I'm 0 degrees. Wait, you can't manage this, can't break this, boy, I'm funded. Gotta keep my distance when you not 100. Those the same ones say they love you, late and funny. You can't match my energy, and yeah, you know it. Way too cold, yeah, man, I'm way too cold. Way too cold, yeah, man, I'm way too cold. Way too cold, yeah, man, I'm way too cold. Yes, I meant it, yeah, man, I'm way too cold. Yeah, I'm killing it, I'm the realest. Ain't gotta say, gotta know you feel it. My flow got a cold, sick as the illest. I know that I'm great and they about to witness me winning. I went way up, about to go again. You see me on the telly, then you tell a friend. If you know I'm about to rain, it'll never end. Cause fat got big dreams, big goals, never settle, gotta keep on going now. You say you got it, and I'm Red Bull, I got the wings and I ain't coming down. I keep it straight, every line is so intentional. This is your moment to let it go. You know that I'm into it, I'm way too cold. You can't manage this, can't break this, boy, I'm funded. Gotta keep my distance when you not 100. Those the same ones say they love you, late and funny. You can't match my energy, and yeah, you know it. Way too cold, yeah, man, I'm way too cold. Way too cold, yeah, man, I'm way too cold. Way too cold, yeah, man, I'm way too cold. Yes, I meant it, yeah, man, I'm way too cold.
October is Breast Cancer Awareness Month, and at Capitol Ford in Santa Fe, we're proud to stand with the survivors, the fighters, and the families who inspire us every single day. And while we honor their strength, we're also helping you with the strength to save with special dealer offers. Like a new Ford F-150 XLT, save with 3.9% APR financing for 72 months. Or a new Ford Bronco Sport, lease for just $399 a month at Capitol Ford in Santa Fe.
Good evening, everybody. Happy Tuesday. We welcome you to another edition of the Pit Press Live. My name is Nick Nunez. I'll be your host tonight, but I'll be joined by the owner, marketing director, one of the main hosts, and the guy that makes the ship drive, Mr. Eric Moulton. Eric, thank you for letting me host tonight, and thank you for being on the show.
Yeah, I figured it'd be a good time to rip off the Band-Aid and let you do a show on your own and produce it, but happy to jump on, and I'm looking forward to tonight's guest and really dive in. Something that's really a kind of intriguing topic that's top of mind for a lot of people, and I think it's confusing to me, but I'm sitting here with two lawyers, so I'll let you guys kind of go at it. But Nick, take it away.
Absolutely. We've got a very special guest here tonight joining us. We're going to break down some legal topics that affect college athletics. Our guest tonight is an assistant professor from Boise State University in the Business Management and Legal Affairs Department. He's done extensive research, writing, and has provided expert legal commentary on all legal issues involving college athletics, including the House settlement, eligibility lawsuits, and the Pac12 Mountain West Conference lawsuit, which we will talk about here in a second. You can follow him on X at Sam C. Ehrlich. Check out his website at collegesportslitigationtracker.com. Tracks all lawsuits involving college athletics. Dr. Sam Ehrlich. Sam, thank you for joining us on the show tonight on the Pit Press Live. How are you doing?
Yeah, of course. Thank you so much, Nick and Eric, for having me. I'm doing great. It's finally, like I was saying before, it's finally getting a little cold up here in Boise, so I'm pretty happy about that.
Yeah, well, we see you're wearing your Boise blue, and we've talked extensively on our last show about the game Saturday night. Boise State defeats UNM 41-25 in Boise. You said you got the opportunity to watch the game. Sam, what were your thoughts?
Yeah, unfortunately, I wasn't able to be there at Albertson Stadium, but given all the rain, maybe it was for the best. I was down in San Diego for a negotiation competition, but yeah, I was pretty happy we got out of there without a big upset in our hands. Coach Eck has you guys playing hard. Glad that obviously I'm sure all you guys and your viewers would disagree, but I'm glad we were able to pull it out in the end, because that was, going into it, I was a little bit worried about this one. And from that first half, it was, that worry definitely was justified.
Yeah, no, definitely. It's kind of a weird game in that neither offense really got going until the second half. Boise State, I think they just, Eric and my dad broke it down. Sean Ryder and Jeff Grammer from the Albuquerque Journal. Lots of people here in Albuquerque have kind of broke down the coverage of the game. But Boise State has a big one coming up against UNLV. So I guess we'll kind of see that'll be for first place in the Mountain West Conference. But another win for Boise, and I know you guys are surely happy to be walking out of there with the win nonetheless. But why don't we dive into some legal topics, Sam? I know the average college sports fan hates talking about lawsuits involved in college athletics, but for guys like you and I who, enjoy looking into this stuff, diving into the legal issues, and, hopefully finding some solutions or explanations for people rather for kind of how this stuff is going. There's a lot to talk about with the law in college athletics. There's so much going on. I guess we'll kind of start with the Pac12 Mountain West Conference lawsuit, because I know a lot of fans in the Mountain West, and for teams like Boise State that'll eventually be making the jump to the Pac12, but that's a hot topic. But there was some news that came out in September. The judge in the case in the federal district court denied the Mountain West Conference's motion to dismiss. So the case is going to move forward with litigation now. The parties tried settling this case in May, I believe, May and June, and the settlement didn't go anywhere. They filed a joint status report with the court, letting the court know on July 15th that they were not able to settle the case. And so, again, the judge denying the Mountain West Conference's motion to dismiss, I think the order came out on September 9th. Just first question for you, Sam. Does the judge denying the Mountain West Conference's motion to dismiss give any indication of how this judge will rule on any further attempts by the Mountain West Conference to try to dismiss this case?
Not really. I actually really don't think so. And that's speaking as, even from my position as someone who, is rooted for a Pac-12 school, which, kind of similar to our discussion about the football game, and, kind of maybe a different standpoint, maybe a different viewpoint from you and your viewers. But even me said, kind of reading that motion to dismiss. And for one, I think it's important to keep in mind kind of the standard for motion to dismiss. A motion to dismiss is, just essentially the requirement is that you have to, the judge and really the other party even in filing the motion to dismiss has to look at the complaint, look at what's pled by the plaintiff, and accept every single fact is true. It's completely agnostic of facts. It's completely agnostic of, maybe later kind of, some expert testimony that can come out during discovery. And it's really just based on, whatever the Pac-12 pleaded. If you accept all of that as true, is there a viable legal claim here? And really more than a lot of these motion to dismiss decisions that I see. And I think it was, I don't know if I necessarily read much into it or not, but this decision in particular, if you read it, it was very, very hesitant to take really much of a position beyond there's a viable claim here. It needs to go through discovery. There wasn't really anything that said, this is absolutely, there's a likelihood of success here, because that's not the standard. There was nothing in the decision that said, well, this seems like a strong claim or a weak claim, because again, that's just not the standard. It was just, this is enough to survive a motion to dismiss. And so, I don't think we have a whole lot of answers on it. I do think it was interesting, that some of the claims were preserved, even some of the claims that maybe, just myself thought were, less strong than some of the other ones. But I think the fact that all the claims were preserved, it's definitely telling. It definitely is going to go back to a settlement talks potentially, but definitely not an indication of how the judge is going to rule overall.
Yeah, Sam, and this is a antitrust case like many of the lawsuits involved in college athletics. I think the Pac-12's argument is that the penalties, the termination clause in the scheduling agreement that was entered into between the Pac-12 and the Mountain West Conference it restricts competition, which is kind of the theory behind their case. And it gets really complex. You mentioned it. The parties are going to have to get into discovery, take some depositions, maybe disclose some expert witnesses. But if you had to put your finger on it, Sam, which party do you think has the stronger position in this case, the Pac-12 or the Mountain West?
I think there's, if you were to kind of make me say it, if you were to really kind of hold me to it, I would actually kind of be split on it, because I think the antitrust case, I think it's going to be difficult for the Pac-12 to be able to show the requisite market power, because at the end of the day, the theory is that the Mountain West, the whole Mountain West Conference kind of banded together, and that contract combination and conspiracy acted anti-competitively towards the Pac-12 and kind of forcing them to accept terms that were beyond what they would take in a normal in a normal market without that level of collusion. And for one, you have a lot of different programs out there. You have a lot of different conferences out there. You have a lot of different teams that the Pac-12 can partner with in this kind of thing. So it's an interesting test in a lot of ways, because generally speaking, when we're talking about conferences, whether the conferences themselves, individual conferences, kind of through their, collective power have the ability to kind of create that, have that market power, and have the ability to create these kind of collusion claims. It's really kind of been untested, but it's a very important issue, very interesting issue kind of moving forward in a lot of different ways. It's also one that's being tested on the other side of the country by in a case involving the Ivy Leagues, where you have some plaintiffs challenging the Ivy Leagues prohibition on athletic scholarships, just a blanket conference-wide saying none of us are gonna offer athletic scholarships, unlike other conferences. But that's the antitrust claim. I said it's a split decision, and I think it's kind of funny. Like, the antitrust claim is kind of the main claim here. It's the one that's really kind of impactful. I actually think the liquidated damages penalty clause claim is a lot stronger, which is kind of funny, because that's kind of a one of the later claims in the complaint. The antitrust claim, sure, I think there's there could be some merit to it. I think it's weaker, but the argument that, and liquidated damages is essentially, for breach of if you have a breach of contract, you have damages spilled out in the contract that say this is how much you're going to pay, like a buyout. But the problem with liquidated damages clause, the thing about liquidated damages clause, is that they have to be reasonable. They have to reasonably estimate the damages that the non-breaching party would suffer. And I think, calling it a poaching clause, calling it something where it's a penalty for breaching this agreement, it's a penalty for breaching the agreement by taking, the agreement not to take Mountain West players without paying a certain fee, that could definitely be seen as an unenforceable penalty clause. And I think that is actually a fairly strong claim. And I think even reading the motion to dismiss, like, if you're going to read anything into it, it seemed like that part of it may have been something where the judge said, that's might be a better claim.
We're speaking with expert legal commentator and assistant professor for Boise State University, Dr. Sam C. Ehrlich. Sam, what do you see this case coming down to? Is the Mountain West going to have to settle for a reduced amount of penalty fees, and also some of the fees in the other companion case involving Boise State, Utah State, and Colorado State, involving the bylaws provision? So there's two separate lawsuits involving the Mountain West and the Pac-12 and their schools. But do you see the Mountain West settling this case for less money, or how do you see this case playing out?
I definitely think there's going to be a settlement. I think everyone who's kind of watching this expects there to be a settlement. I think a lot of people expected there to be a settlement before the motion to dismiss. But I think it was reasonable for the parties to kind of wait for the motion to dismiss to say, we're actually going to move on these terms. Like, apparently, according to reports by Jen Cazzaro and John Wilner, the Mountain West was really kind of very unwilling to move on their negotiated position, and for good reason. I mean, they had the motion to dismiss in their back pocket. They felt like they're going to win, at least knock out some of the claims on this motion to dismiss. And now that we're past that point, now that we've seen the motion to dismiss go in favor of the Pac-12 and not dismiss the case, it gives the Pac-12 significantly more leverage here, and it reduces the Mountain West leverage here. I mean, it's still not, and I think, I've seen some pushback on that, saying, well, if you read the motion to dismiss, it's very much, and like I said, I just said this before myself, it's very much not indicating that the judge is inclined to rule in one way or the other. It's not a signal that, the Mountain West better settle this, otherwise they're going to lose. But it does up the stakes quite a bit. For one, you're going through discovery. Discovery is always a timely and cost intensive and really difficult process for anyone to go through. You really don't want to go through discovery if you don't have to. So I think the parties getting together before discovery really starts to ramp up and settling this case, I think makes a lot of sense. But also for two, I think both parties are in a situation right now where there's a lot of risk in going to trial. It's not only expensive to go to trial, but if you lose, you've spent all that money just to have the outcome that, just to have the worst possible outcome. Either, the Pac-12 gets nothing because they lose the case, or the Mountain West gets nothing because they lose the case. So at the end of the day, I think there's a lot of incentive for the parties to meet in the middle.
Sam, one more question for me, and then I'll turn it over to Eric. But I think people are naturally wondering, what's the timeline for this case coming to a resolution? I can't remember when the lawsuit was filed. It's probably around a year ago this time. Then they tried to mediate, didn't work. Motion to dismiss gets denied. I think the parties filed a joint stipulation, which allows the Mountain West Conference to answer the complaint and assert their counterclaims. They have until October 23rd to do that. But what do you think the timeline is for this case?
It's going to take a while. For one, cases like this always take a while, because especially when you're talking about antitrust cases, antitrust just ups the stakes exponentially because the discovery requires significant economic analysis. You have to show, because antitrust requires kind of showing that market power, really showing the economics behind all of this. It requires a lot of expert testimony. It requires a lot of depositions. It requires a lot of evidence. I've seen some antitrust cases take multiple years just to go through the discovery process. I mean, we saw this with House. We saw the House settlement this summer. People forget this case. The House case was filed back in 2020. I mean, these cases take a really, really long time. So it could be several years. It could be just a few months before we reach a settlement. I mean, it's kind of hard to tell.
Eric, any questions for Dr. Ehrlich?
Yeah, and I want to kind of take a step back for us non-lawyer folk, but really wanted to clarify, like, what exactly is being challenged here from the Pac-12 and some of the exiting members of the Mountain West, because you have your poaching fees, which was built into that joint contract that allowed some of the Pac-12 members to compete with the Mountain West once the original Pac-12 dissolved. But then you also have the exit fees that are tied to the Mountain West members that have to owe back basically the buyout to leave the league to join another. Are both of those fees kind of being challenged right now in terms of that antitrust? And so essentially both could either be settled on, and that kind of almost doubles the reduction in what the Pac-12 is after. Am I making sense of that right?
No, you are. The only difference is that the poaching fees are being challenged under antitrust law. The exit fees are the subject of a separate lawsuit in Colorado State Court involving, a few of the exiting schools, including my employer, Boise State, filing a lawsuit against the Mountain West. And that's
it's not all schools that did that, right? It was only a few schools that
it was only a few schools. I know for one, Fresno State was not a part of that lawsuit. And I guess San Diego State would not be as well, because I learned this later, kind of an interesting little thing, but it makes sense when you think about it. Cal State schools, like the schools in the California state system, like Fresno State and San Diego State both are, can't sue other members of the Cal State system. And San Jose State is a member of the Mountain West. So I guess that's covered. So that explains why those two schools are not part of the lawsuit. So it's only Boise State, Utah State, and Colorado State who are plaintiffs in that lawsuit. And that lawsuit, again, it's a pure breach of contract claim, or it's a pure contractual claim. They're trying to get the exit fees declared as void for a variety of different reasons. And then the poaching fees are the subject of the antitrust case in the California court. That I think is more front of mind for all of us.
Okay, go ahead, Dick.
Yeah, Sam, we'll kind of switch gears a little bit and talk about some eligibility lawsuits. For our viewers, these are cases where players are asking the NCAA for an additional year or more of eligibility, and they kind of challenge the NCAA's eligibility rules in their bylaws, which limit players to 4 to play 5 years, or 5 to play 4 years of eligibility. So you get 5 seasons to play 4, of which you're in college athletics. One of the most well-known is probably Diego Pavia, Albuquerque native, Vanderbilt quarterback. He was given another year of eligibility by the NCAA after a district court judge in a federal district court in Tennessee granted his preliminary injunction when he filed a lawsuit against the NCAA. And Sam, I know you'll dive into this, but what happened with him is, Diego Pavia plays 2 years of junior college. Then he plays 2 years at New Mexico State and then goes and plays at Vanderbilt. And he said that it's unfair that because he played junior college that those years count against him. And then, the district court grants a preliminary injunction. It went up on appeal. It was heard by the Sixth Circuit Court of Appeals. I believe, according to your X account, you watched the oral arguments in that case. So can you kind of give us your thoughts on those and where you see this case playing out?
Yeah, so the Pavia case is a really interesting case, and it's one that spawned several dozen kind of copycat cases just because of how it ended up. I mean, the fact that Pavia was able to win that case, the fact that he was able to get an additional year of eligibility, it led to a lot of players saying, "Hey, why don't I get that myself?" You hit the nail on the head when you're kind of describing, when you're discussing the Pavia case, and really talking about kind of how that really kind of was created in the first place, and how and really what the claim behind it was. It was he played 2 years of junior college. One of them was wiped out of the COVID year, but he's saying, "Hey, well, I still have a year under my 5-year clock. I still have the ability to play one more year if you don't count junior college at the same as a Division I year. And why are you counting this year in junior college where I wasn't able to make any money? It was before NIL even. The same as a year in Vanderbilt where I'm making a ton of money and I'm playing in the SEC." And he went to the district court. He made a number of arguments, again, on this antitrust ground, saying that, and kind of similar to, antitrust is so commonly applied to price fixing. When we saw this in the Alston case, we saw this in House v. NCAA, where you're fixing the salary at a certain point and kind of collectively agreeing not to go any higher. Now it's just essentially years fixing. It's saying, the argument is saying you're limiting us to a certain amount of years and not allowing us to do more. And especially with the counting junior college part of it, he also made the argument that you're really actually disadvantaging me because I played junior college. You're essentially creating this group boycott of me because I played junior college, and really disadvantaging a lot of other junior college players out there. And the court agreed with it. Went to the Sixth Circuit. They actually declared it moot because what had happened after that is kind of interesting and kind of a bit of a self-owned by the NCAA, if I'm being honest, because I think we all kind of heard about this when the case happened or when the decision happened. Pavia was able to win this preliminary injunction, and the NCAA's response was, well, we don't want this flood of other litigation coming in. We don't want a bunch of other players suing over the same thing and having to defend ourselves in all these different courts. So we're going to issue this waiver. We're going to issue this blanket Pavia waiver, saying that all athletes in Pavia's situation who played junior college or played in a non-NCAA league prior to or during, I guess, their college career, get that extra year if they still have a year on in their 5-year clock. But that part was really key because while they did that, players who have exhausted their 5-year clock because they redshirted, they said, well, wait a minute, why can't I get the same thing? There's a lot of confusion over the rule. In fact, in Jet Elad's case, safety at Rutgers, Greg Schiano, the football coach at Rutgers, actually testified in court. He said, our compliance office gave Elad the green light. They thought that he was covered under this Pavia waiver. It wasn't until later that the NCAA clarified and said, it's only players who haven't redshirted. It's only players who still have the time within the 5-year clock. So you saw a ton of different lawsuits involving players who had exhausted their 5-year clock, even if they still have a junior college year. You've also seen lawsuits involving players who maybe they played Division II instead of JUCO, and they're making kind of similar arguments. And then you've also seen, including the tweet that you just highlighted, you've seen lawsuits involving players who are saying, well, wait a minute, you have this 4 seasons and 5-year rule. Why am I not allowed to play all 5 years? And that's probably the next frontier in all of this.
We're speaking with Dr. Sam C. Ehrlich, professor at Boise State University. Sam, question about who the Pavia waiver applies to. As you mentioned, the NCAA issued a waiver to players like Diego Pavia who are similarly situated. A player for UNM men's basketball, Utah State transfer Dayton Albury, I believe is in a similar situation to Diego Pavia, played 2 years at a junior college in Florida. transferred to Queens College in North Carolina, where he played 1 year. Then he played at Utah State. So he seems to be one of those folks who falls into the same category as Diego Pavia. But if you could let our viewers know who the Pavia waiver applies to.
So very specifically, it applies to players who they have a JUCO year or a non-NCAA year. They also consider NIAA as part of that, and NJCAA and all these other non-NCAA schools. So they have at least 1 year of junior college or whatever, and they have not exhausted their 5-year clock. And that's the key part of it, where they haven't exhausted their 5-year clock. Where if they have a redshirt year, which means that they have 5 years in the NCAA, even if you take out one of the years for a COVID year, so 6 years if you include the COVID year, they would not be eligible. They would not be covered under the Pavia waiver. And from everything I've heard, the NCAA is very strictly enforcing that. They're not granting waivers to players in most cases who have exhausted their 5-year clock but have that junior college year.
Eric, any questions for Dr. Ehrlich on Diego Pavia?
I don't, man. No, this is all super interesting to me. Especially the Diego Pavia stuff. I didn't know that about Dayton Albury. I'm sure that there's a lot of players that fall under that clause. It's just who's kind of willing to come forward and challenge the courts and retain an extra year of eligibility and collect NIL money. I think that's kind of what kickstarted all of this, right? Especially someone who's in the limelight like Diego Pavia, who's collecting a lot of money. And if you can get an extra year out of that, it's life-changing for some of these guys, because you don't know when it's going to all end, right? And if you're not going to make it to that NFL top tier, then kind of what's next? So they're trying to capitalize on their name, image, and likeness. So all very, very good, interesting stuff. I appreciate you coming on, Sam. Again, very, very insightful, and I'm learning a lot. But no questions. It's kind of all over my head at this point.
No, that was a good take, Eric. And for Dayton Albury, I'll have to go back and check. It just caught my attention that he had 2 years of playing JUCO. So I'll have to go back and look and maybe add the math up. But last question on Diego Pavia, Sam, is what's on the line for him? This will be his 5th year playing, college athletics, so to speak, not counting the COVID year. He's going to turn 25 in April. I know he tweeted out, and I think you retweeted his tweet, that this is going to be his last year. But I thought I saw a reference to you also that his attorney said during oral arguments in front of the Sixth Circuit that they may challenge the redshirt rule. So what's on the line for Diego Pavia when he's already going to play 5 seasons? Yeah,
that was a little strange because I definitely remember, and I looked back at the transcript, and it was absolutely the case. I felt a little bit like a fool when I tweeted and it blew up, and then Pavia himself came out and said, "Nope, this is my last year." But his attorney absolutely said in front of the Sixth Circuit that if the case is mooted, which it was, or if in any other way he was able to preserve his preliminary injunction, he was going to come back. He was going to continue the case and seek a preliminary injunction for next year as well, challenging the redshirt rule. And maybe Pavia's attorney got instructions after. Maybe there's some crossed wires, or maybe he's just saying it in order to try to get the case not be mooted, because he wanted the Sixth Circuit to rule on the merits, and because Ryan Downton, Pavia's attorney, he has a lot of other cases. He has a lot of other cases at this point. He'd love to have the Sixth Circuit rule sooner rather than later in favor of his client, just so there's a lot more certainty with those other cases. He doesn't have to go back to the Sixth Circuit on appeal after, if he's able to win, at the lower court. But yeah, to your question, what's on the line for Diego Pavia? Actually, nothing. If it is the case where he is going to be, this is going to be his last year, and he's not going to be pursuing another year under kind of a similar lawsuit, he already has clearance from the NCAA that he's going to be able to play the rest of the year because of that Pavia waiver. And that in fact is the reason why the case was mooted at the Sixth Circuit. The appeal was mooted at the Sixth Circuit because the Sixth Circuit said, well, the NCAA appealed this case. They're trying to get this preliminary injunction overturned, but the result of overturning that preliminary injunction would be the exact same thing that would happen if we didn't do it, because the NCAA has already acknowledged that Pavia is going to be able to play regardless. So the Sixth Circuit wasn't able to hear the case because there was just nothing at stake on it. It wasn't something that really necessarily mattered for Pavia specifically, whether or not the Sixth Circuit ruled in his favor or not. So
right.
Yeah, no. and I think that's a signal right there that maybe Well, I mean, I guess I wouldn't say it's a signal that he's not going to do anything about it, the fact that it was mooted, but it'll be interesting to see moving forward whether he changes his mind and looks for that extra year, or maybe it's attorney convinced him to do it. But either way, we have a lot of other challenges to the redshirt year, redshirt rule, and a lot of other cases that I think will be interesting to watch.
Yeah, one of those other cases that I wanted to ask you about was Jacob Manu, who you tweeted about, I think, earlier this week. He's a linebacker for Washington that transferred from Arizona, and he's challenging the redshirt rule, like you just mentioned. And I think in the clip that you posted on your X account, you point out how he illustrates that, you know, a player could use the redshirt in football, talking college football now, where you get to play in 4 games before you lose your redshirt. But it talked about how a player could play in 4 redshirt games, and then they could also play in a conference championship game and in the college football playoff games, which I guess now under the current version of the bylaws don't apply. And that person would still get to preserve their redshirt. But if someone gets hurt in week 7, like Jacob Manu did last year from Arizona, they don't get to preserve their redshirt rule. Do you think he has a good argument in this case, Sam? Sam, are you still with us?
Oh, I'm breaking up there. Can you guys hear me all right?
I can hear you now, yeah.
I'm still.
Yes.
Hello? Yeah. Wasn't sure what was happening. Things are breaking up a little bit, but I think it was on my end. But either way, yeah, I think Manu has a really interesting case. I think it's one that really kind of hits at the heart of a lot of the arbitrary nature of so much of the redshirt rule, with, you know, the kind of the four games, and how it only applies to in football, and how, you know, it doesn't apply to playoff games like you were talking about. And I mean, it is important to note he's challenging an antitrust law the way all these other cases are. And arbitrary, you know, whether the rules are arbitrary or not isn't necessarily all that important for antitrust analysis, but it really does in some ways kind of, you know, what it. I think it's important because, you know, antitrust is all about kind of balancing the anti-competitive harm against the pro-competitive benefits, and the NCAA keeps saying, well, there's pro-competitive benefits to keeping it tied to education, to keeping it tied to, you know, your normal academic calendar. But I think Manu, you know, can come back and say, well, and you know, this is what he did in the complaint, and this is really kind of how he was highlighting it. Those pro-competitive benefits don't really make a whole lot of sense when you're allowing some players to play basically half the season if they go all the way through the college football playoff, and you're not allowing, you know, players to play who just played the rest of the season. Like it really doesn't really, you know, work towards that pro-competitive benefit as cleanly as it does. And I think one really crucial thing for Manu in particular is the fact that he filed in Washington. He filed in, you know, the fact that he filed in Washington means that it's in the Ninth Circuit jurisdiction, and the Ninth Circuit has been particularly negative against the NCAA, you know, for a while. I mean, they're the ones who heard the O'Bannon case that went against the NCAA. They're the ones who heard the Alston case that went against the NCAA. So if it goes to the Ninth Circuit Court of Appeals, which you're already seeing a couple of cases go to the Ninth Circuit Court of Appeals in these cases, the Cole Braham Jr. case, the wide receiver out of Nevada who transferred to Memphis, and Tao Martinson, who was at Nevada and transferred, or was at UNLV and transferred to San Diego State. Those, you know, Manu's case can get a major shot in the arm if the Ninth Circuit rules in favor of one of those two players.
Yeah. Eric, I want to bring you into this. I think this is something that, you know, you can certainly relate to, is I think, like we were talking about when we started with Sam, most college football fans or college sports fans would rather not see the lawsuits, right, Eric? I mean, we kind of just want to see some stability in college athletics so that these don't dominate the headlines. It's not as bad when games are being played. You know, football, basketball is about to start here in about half a month. So people pay less attention to it. But this summer, I mean, the House settlement was such a hot topic. But, you know, kind of what are your thoughts, Eric, about, you know, lawsuits in college athletics and, you know, college athletics just kind of being a distraction to everything? I think you might be on mute, Eric. Get you quick.
Yeah, no, it's definitely a distraction. It takes away from the game that we all love, and it kind of forces the conferences into this money grab too, and kind of what is driving this realignment. It's all related, I think, and it's definitely pulling things apart. Like you think about the Mountain West kind of being one of those conferences that took the heat of most of it, because you see all these rivalries and all these existing fan bases just being ripped apart for the sake of realignment. And then now you have players that are transferring to basically see a higher payday. I was listening to a podcast on my way to work this morning, Rocco Miller, who covers college basketball extensively. And what he was saying was, man, you look at some of these schools, and he was referring to the mid majors around the country, that some of the smaller mid majors, he would not necessarily classifying the Mountain West as being a mid major, but some of the ones that are kind of beneath that, you have guys, you have a good season put together. Those guys are going to make an all conference team, right? And then I forgot which league it was. I think it was the NEC, but they had, right, 15 guys make all conference for second and third team. 11 players out of the 15 that made all conference end up transferring to a much more prestige university to play basketball. So it's just like tearing apart teams, and it's really driving more of a divide between the schools that have the money, the haves, and then the schools that don't have the money, the have-nots. So
Yeah.
it's just a feasible model, and it's not what people are excited about, right? I think a lot of people like the rivalries. They like the regional aspect of having the conferences, being able to travel to watch your team on the road. But now it's even talking about, right, like the NCAA tournament and March Madness, which everyone loves. They're talking about adding 76 teams now,
Yeah.
because the NCAA wants to make more money on TV revenue for offering more games. But then Rocco Miller also talked about it again. If the 76 teams, the new KenPom rankings came out of the top 100, all 75 or 76 power schools, so everyone in the Big 12, SEC, Big 10, all those programs were featured in the top 75 of KenPom. So you're just seeing this like shift of power and money more to the top, and the schools that fall kind of in the mid-major class, which is the Pac12, which I still think is going to be another mid-major conference. But then the
Yeah.
Mountain West, the NEC, and the Big West, and like the exciting programs that everyone wanted a Cinderella for in March Madness, it's just going to become more and more challenging for that. So that's kind of my stance on it. It's very unfortunate to see, but it's really hard to disrupt the trend when it continues to go the way it's going, and especially when people are taking it to litigation and to courts and letting the courts decide how this corporation is going to function now and how the money is going to be divided and shared. It's, I don't know. I'm not a big fan of it, but it's inevitable.
I hear you, man. No, I think you hit on some really great points. And then another thing, too, is just the volatility with player turnover in college athletics. I mean, players they have an unlimited transfer, so they're going to be sometimes in 4 different places in their entire career. And it's hard for the average college fan to get loyal to that, you know? So speaking of that, once again, our guest is Dr. Sam C. Ehrlich, professor at Boise State University and also an expert sports legal commentator. Sam, the final topic we wanted to ask you about was maybe some solutions to some of these lawsuits in college athletics. Right now, there's 2 bills being proposed in U.S. Congress. The SCORE Act, which was proposed in July, passed 2 committees in the House. It would give the NCAA an antitrust exemption, but there are a lot of problems with this bill. It's drawn a lot of criticism. Then there's the SAFE Act that was introduced in the U.S. Senate in late September. The bill provides protections to student athletes in NIL deals. It would limit transfers, lots of other protections. But tell us what we need to know about these 2 bills and whether you think either one of them provides any permanent solutions to ending lawsuits in college athletics.
Yeah, I mean, I'll start with that last point. I don't think either of them are going to be much hope for anyone who kind of wants that stability in college athletics for a number of different reasons. For one, I think both of them are going to find immense difficulties in even passing through Congress in the first place. We have, looking at the SCORE Act, for example, we have, maybe some momentum in passing it through the House, but you have basically every Democrat at this point, minus a few that are pretty strongly against this bill, or at least want some major concessions out of it. And I guess we'll see what happens to kind of, apparently they're still negotiating on it through the government shutdown. I'll be really interested to see what the bill looks like the next time it's brought up. But I mean, there's a reason why we just saw it kind of get delayed. It was originally going to get a House vote a couple of weeks ago, a full House vote, and that got pushed back because they just didn't have the votes over it. And partially because of the Democrats, and partially also because Cody Campbell, the big Texas Tech booster whose plan involves kind of amending the Sports Broadcasting Act. He rallied a bunch of Texas Republicans to go against it as well. And, we're seeing, again, we're just seeing a lot of opposition to the SCORE Act, and that makes for a very difficult, passage through the House. And then you get to the Senate where, you need a filibuster, you need 60 votes, and they just don't have any votes, from what I know, at least. I'm not a politics expert, but just from what I hear, they just do not have those votes in the Senate. So it just seems like that's not going to pass. And then the SAFE Act is even simpler, kind of in that regard. It's a Democrat bill. It's both houses in the presidency are controlled by Republicans, so it's not going to pass. Even if you hear some reports that apparently President Trump prefers the SAFE Act because it incorporates the Cody Campbell plan, but I just don't see it even going anywhere. I mean, I think it's a counter proposal, and it's one that maybe you kind of try to merge the difference on a little bit, but it also leads to another problem that I kind of see, and I have a forthcoming article on this. I just turned in an article to Matt Brown's Extra Points on this as well. I actually think the SCORE Act's unconstitutional. I don't think it's something that can survive constitutional scrutiny, even if it is passed through both houses. Like I know Mike McCann at Sportico has written about potentially violating equal protection, just in the way that it, forbids athletes from being employees. But I also think that the way the SCORE Act is structured and giving a lot of regulatory and legislative power to the NCAA and to the College Sports Commission, it violates something called the private non-delegation doctrine, which forbids Congress from delegating its legislative authority to private entities. And it seems really, really clear to me that the SCORE Act wholly violates that provision, that doctrine. And I just don't see a way around it unless they significantly modify the bill.
Speaking once again with Dr. Sam Ehrlich, you can follow him on X at Sam C. Ehrlich. Check out his website at collegesportslitigationtracker.com. Sam, we cannot thank you enough for joining us here tonight and talking all these topics about the law on college athletics.
My pleasure, Nick. My pleasure, Eric. Thanks so much for having me. And happy to jump back on when there's more news to talk about.
Absolutely. We'll be bugging you down the line. Sam, have a good night. Thank you.
You too.
All right. All right, that was Dr. Sam C. Ehrlich, professor at Boise State University, breaking down some legal topics in the law. We're here on the Pit Press Live. I'm Nick Nunez here with Eric Moulton. Eric, what did you think of Sam Ehrlich?
Man, he definitely knows his stuff. And just hearing you guys talk, banter back and forth about the law, it's a lot deeper than I even want to stick my head into, because I'll end up getting lost. But he knows it inside and out, and I think he's paying close attention. I see his stuff all over Twitter, and I see other lawyers on Twitter like Mitt Winter, who's very locked into the NCAA and everything that's kind of been unrolled, and different cases. I think the Pavia case is definitely interesting because it hits close to home, right? He's a local Albuquerque guy. But yeah, I think he's very credible. I think he's knowledgeable. It's nice to get his take on things, and he explains it in a way that I think kind of resonates with someone like me and maybe the rest of people that like to join our show. Someone that might not have that law degree or understand some of the terminology, but I pay close attention to it, so I understand some of it. But I think he would. The way he gets the message across, it would make sense to someone that might not understand it as closely. But it's I stand firmly on my opinion on what I said earlier on the show. Just I don't agree with everything that's going on, just because of the way it impacts UNM, the way it impacts the Mountain West, and how it's kind of tearing apart college athletics. And it was the thing that we loved about college athletics compared to pro sports. But I think at this point it's inevitable and kind of transforming into professional sports, and everyone's trying to get there. So who's to blame them? But it kind of took a little bit away of everything we loved about the college sports framework.
Yeah, I know for sure, man. God, he's such a book of knowledge. He knows so much. Lucky to have him on. We also had him on this summer to break down the House settlement. But looking ahead, Eric, Lobo sporting events this week. UNM men's basketball has practice tomorrow. Head coach Eric Olin and a few players will be available to the media. starting at 8:45 a.m. I know some of us are going to try to attend, Eric. I'm not sure if I'll be able to, but I think my dad's going to be there. And it was really great. You know, we talked about it, I think, the last time we broke down some Lobo basketball, but they're doing this now where they're allowing the media in to interview some players, to ask Coach Olin some questions. They allow the media to observe practice, no reporting on what's going on at practice. But, you know, we're there covering Lobo athletics. And I know you and my dad were talking last night, Eric, about the excitement behind this Lobo basketball team. But it's exciting, man. They got their first scrimmage October 25th in Pullman, Washington against Washington State.
Yeah, no, I think I'm most excited to see these guys play up against each other, play some actual competition, and stop running some of those ghost drills and those ghost offense motion. It's kind of really hard to get a grasp on how these guys can play at actual game speed, right? I think we've seen a few of these guys like Albury. I mean, he played against UNM last year, so we definitely know what he can do. But there's a lot of high hopes and expectations for some of these guys that are coming in, high sought out recruits. But at this point, they're just kind of, I don't know, opinions. I think they're kind of what we've seen before, but it's how it comes together and how they gel, how they play on the court together. I think I'm excited to see how Olin's offense finally comes together and how they execute on the floor together. But yeah, it's really hard to get a good firm look at these guys when we've been limited on what we can actually see. And it's not just us, but I think it's all media. And I think that was intentional. And I said this on the show last night. I think they're not trying to take anything away from Lobo football at the moment. So they're somewhat having a decent, successful year. And they're not wanting to steal any thunder away and kind of transition or refocus the Lobo fan base on Lobo basketball since we're about 3 weeks out. So I'm glad it's back. I'm glad Lobo football has a winnable home game. I think it's a must-win situation, but I think there's a lot going on, and we here at the Pit Press are fortunate enough to be able to get the access that we do and talk about it how we do, where our opinions are our own, but we cover it from an objective standpoint. And I'm glad that we get to have the close looks that we do, but always happy to chop it up with you and your dad and everyone else that joins the show.
For sure, man. We appreciate the opportunity to be on the platform with the Pit Press Live. Once again, Lobo football in action on Saturday, 7:45 kickoff. They'll take on Nevada. It'll be aired on FS1. Get your tickets. Get to University Stadium. Support UNM football. Eric, it's been a great show, man, having Dr. Sam Ehrlich on, breaking down the law, talking a little bit with you. Anything else?
No, I think we'll probably get some more announcements coming out in the next week or so. Future guests, I mentioned Rocco Miller, covers college basketball the whole country, primarily mid-major basketball. We'll get him on. Brendan Williams from Go Lopes covers GCU. We're going to probably get Steve Ivey on from CSU to cover some Colorado State Rams basketball. We got the UNLV podcast guys coming on too. So a little bit more basketball focus in the next coming weeks, and we'll get it scheduled, and we'll make sure to let everyone know ahead of time when we'll be coming on live. But if you haven't already, check out Nick's stuff on the site. You've done some writing recently covering the basketball program. I know Greg Archuleta has also written some more stuff on football. So we appreciate everyone's support. And if you don't already subscribe to the YouTube channel and go check out the website. So that's all I got, Nick. Any last thoughts?
No, that's it, man. That's it. Our guest tonight was Dr. Sam C. Ehrlich, professor at Boise State University and expert sports legal commentator. For Eric Moulton, I'm Nick Nunez. You've been tuning in to the Pit Press Live.